It's important to know that there have always been very, very strong arguments and feelings about, for example, the Constitution and what rights it should protect and what rights it shouldn't, what limits it should put on government, what limits don't exist. And this comes up, for example, in terms of the president's power to deploy the military. I'm reassured, and I try to reassure people that these arguments have been going on a long time, and they're not necessarily unhealthy.
Hi everyone, welcome to the Vandal Theory, a podcast about science and research at University of Idaho. I'm your host for the day. I am Danae Lenz, the External Communications Coordinator at U of I, and I am joined, as always, by Lee. Hi Lee.
Hi, Danae. I'm Lee Cooper, University of Idaho science writer and editor.
So today we're going to talk about constitutional law, and I want to know, how much do you think about the Constitution in your day-to-day life?
Probably more than one would guess. I've always been politically minded and have followed things along, but I definitely ratcheted that up when I actually lived in DC for a couple years. And just because it's so in your face there, the rallies are there, the history is there. When I walk to work, I'd go by the Vietnam Memorial. Since then, I've stayed pretty well politically informed. And over the past 10 years, again, I'm not sure if this is because I'm paying more attention now or because it's just come up more. You hear a lot of newscasters and politicians asking the question, is this thing that's happening constitutional? So I have done a decent amount of diving and rabbit holing on different topics to learn about that.
I also probably think about it more than your average person. I had very politically engaged parents when I was growing up and to this day. So, yeah, it's kind of been in the background of my life most of my life. That said, this interview today still taught me things that I didn't know. It really opened up my mind, and I'm real excited to get into it. We're talking to Richard Seamon today. He's a professor of law in U of I's College of Law and an expert in constitutional law. In this episode, he walks us through Constitutional Law 101 and breaks down how judges interpret a 200-plus-year-old document. And maybe even at the end, he gives us a little hope for the future. You ready to get into it?
I vote we get going.
Hi, Rich. Welcome to the podcast.
Thank you. I'm happy to be here.
To start out, can you just introduce yourself?
Yes, my name is Richard Seamon, and I'm a professor of law at the University of Idaho College of Law. I've been here since 2004.
We're going to talk about constitutional law today. And just to put us all on the same level, can you just give us a bit of a breakdown about what constitutional law is?
Yes, it really is the system of government that we have in the United States. It establishes the powers of government. It puts various limits on those powers, and it also guarantees certain individual rights or liberties.
Okay. And what is distinctive about our system?
Our system is distinctive because it's called a federal system. We have the federal government, of course, which applies everywhere and has power over the entire country. And then we have all of these individual 50 state governments that have power over the folks who live within the state borders. And that's not even to mention the Indian tribes and territories and things like that. But when we use the term federal, we talk about this idea that we really have both state level governments and a federal government, a central government.
Is that different from how other countries operate?
Yes, it's really unique. It's quite unique. I mean, there are no systems that are quite like the United States. It makes things messy, but the idea was to try to diffuse power so that it can't be centralized in any one place, and it grows out of this concern about the powers of the English king long ago over the colonies.
There's obviously different ways of interpreting the Constitution, as comes up when, the Supreme Court is in the news. Can you kind of break down what those different interpretive approaches are?
Yes, I'd say there are five major approaches. You can slice and dice things a little bit differently, but let me just go through them and give you, then we can talk about some examples of how they work. But the primary method is called the textual method, where the judges look at the words of the Constitution and try to figure out what they meant at the time they were adopted back in 1789, 1791. So that's what we call the textual method, and sometimes it's called the plain meaning approach. You try to figure out what do the words of the Constitution mean. And then a second approach is known as original intent. And this is where you try to figure out not so much what the words mean, that's obviously important, but what was in the minds of the people who wrote the words of the Constitution and the folks in the individual states who participated in ratifying the Constitution. That's really focused on the intention of the what we call the framers of the Constitution and the ratifiers of it. Then the third approach, and now we're getting in no particular order, is what's been called consequentialism, which sounds fancier than it really is. It just means you have to consider what the consequences of interpreting the Constitution one way versus another way are. Look at the implications or the outcomes. Think about the implications. A fourth way is to consult what's often known as natural law or natural justice. The idea being that we as human beings develop certain almost universal laws, like thou, you shouldn't murder people, right? And that almost comes from nature. You don't have to have it written down. You don't even need a government to have these kinds of rules about how we treat each other. So that's the natural law approach. And the fifth approach is known as living constitutionalism, which recognizes that the Constitution was written as a document that was meant to last and ideally to last for centuries. And to make it a workable framework for government, it has to evolve as times change. That's the living constitution idea.
I want to discuss a very specific example and have you explain how a judge in each of those courts might think about the problem.
Sure.
So I was thinking we could discuss cruel and unusual punishment.
Yes, that's a very good choice. Of course, the Eighth Amendment of the U.S. Constitution bans cruel and unusual punishment. It applies in the criminal context, of course, in terms of the sentences that are given to people convicted of crimes. So the textual approach would say, well, what do these terms mean? And more importantly, what did they mean at the time they were adopted? If a person reading the Constitution when it came out of Philadelphia back in 1787, what would they have understood those words to mean? And so if you take that approach, as the U.S. Supreme Court often does, it will actually look at dictionaries from the time and look up the terms cruel and unusual and what does punishment mean. I mean, each of those are terms that had definitions, and they're not necessarily the same as they are today. That would be the textual approach. Now, cruel and unusual punishment is a good example of where, when you look at the words, well, they're pretty open ended and they always have been. And so there's a danger that, what's cruel to one person may not be cruel to another. So courts will often look beyond the text and try to figure out a little bit more about what was behind these words and what was the history behind them. And that's where we get into original intent. What was the intent of the folks who put these words in the Bill of Rights, which was actually ratified in 1791? And when you look at the original intent, you often have to look at the surrounding history, right, to realize why was it put in there. And it turns out that the cruel and unusual punishment concept has a very long history that goes back into British times. Really, its almost direct ancestor was found in the English Bill of Rights from 1689, and it derives from concerns about whoever was in power punishing, in particular, political enemies with punishment that really didn't fit the crime, and that wasn't customary for the kinds of crimes that were being imposed. So that's how original intent would try to give some meaning to these fairly vague terms. And then coming to the consequentialist approach, this might be useful to talk about in terms of the many cases that have discussed whether the death penalty it constitutes cruel and unusual punishment or not. And certainly, I think most people can relate to the idea that one of the consequences of allowing the death penalty to be imposed is that as a statistical matter, mistakes will be made. And so you have to worry about the risk that innocent people will be put to death. And maybe their innocence won't come to light until after the death sentence has been imposed. So that's a very important consequence that needs to be taken into account. And likewise, also concerns about whether the death sentence is being imposed in a way, that is infected by concept things like racism and other problems in the way our criminal justice system works. Now, the next interpretive approach that looks at natural law would look at concepts of sort of long-standing morality and what people have considered to be appropriate, particularly, and that would come into play, particularly when it comes to thinking about, well, what kinds of crimes, if any, warrant the death sentence? And you would sort of consult. I think there you're not so much looking at anything written down, but almost what sort of culture and traditions would suggest about what people think is right and just. And then the living constitution is the last approach I mentioned. And that's particularly important because what's cruel today is not necessarily the same as what was cruel back in 1789, 1791. When you actually look at the history, there were things like floggings, and they used to put people in stocks, in the public stocks in the town square back in the late 18th century. That was not unusual at the time, but certainly would be considered unusual today. The court, in discussing cruel and unusual punishment, has used this concept of evolving standards of decency. That's the concept that the court essentially said that the framers, when they talked about cruel and unusual punishment, probably intended the concept to evolve over time, to take into account changes in what people thought was usual for various kinds of crime. So each way of interpreting this phrase looks at it from a different perspective, and it's not unusual for judges to take multiple perspectives to try to really figure out what's the best way to understand this very amorphous phrase as it bears in individual cases.
Thank you so much for that. I feel like I learned something important today.
Thank you.
So, what happens when the Constitution is silent on something? If something is not explicitly stated in the Constitution, what happens then? How do judges decide if something is a right or not?
Yes, that's a very important question. It is not unusual for someone to appear before a court and claim a right that is not written anywhere. You can't find it expressly stated in the text of the Constitution. And in that situation, the judge essentially has two options. She can decide, well, if it's not in there, I'm going to reject the claim. If the right's not written down, then it should be rejected. But the other option is to see if the Constitution implies the right. And indeed, there's this long-standing idea that the Constitution implicitly protects certain rights, even though they're not written down. And I'll give you an example I think most people can relate to and they probably heard about. So we know that the First Amendment protects freedom of speech. But early on, the issue arose, okay, well, it protects us when we're talking, but does it also give us a right not to speak, not to be compelled to speak? And there's an old case from the 1940s involving a public school that required students to say the Pledge of Allegiance. And there were parents of a student who complained that their child should not be compelled to say the Pledge of Allegiance. Now, they had religious reservations about pledging allegiance, but the court ultimately didn't base its ruling in their favor on their religious concerns. It said The right of free speech includes the right not to speak, not to be compelled to say something you don't agree with and that you would choose not to say. So that's taking the right of freedom of speech and inferring from it this implied right not to be compelled to say things you don't believe. So, and most people would say, gee, that makes sense, right? And it's not a big stretch to recognize that implied right. Of course, problems arise and things become more controversial when there's not some sort of fairly clear, at least textual sort of springing off point, like the concept of free speech. It's not too far a leap to infer a freedom not to speak. There are other rights that the courts have recognized that are a little bit harder to find any specific textual hook for. But again, though, there's a very long-standing tradition, like what we call the Pledge of Allegiance case, where the court has recognized these what sometimes are referred to as unenumerated rights because they're not spelled out in the Constitution.
These days, we have all sorts of crazy technology and stuff that the founders could not have even imagined. How do you take this old document and apply it to things that literally weren't even like figments of their imagination?
Yes, it's a wonderful question that constantly raises problems, and it's the reason why cases have to go up to the U.S. Supreme Court. But let me give an example that is a bit older, but still fits today. Starting actually in the Civil War, the government started to do what we today call wiretapping of phones, listening in on people's conversations. And the question arose whether that violated a person's right to be free from unreasonable searches and seizures. When you listen in on someone's conversation, are you really sort of doing some kind of search? Or when you're recording their conversations, are you seizing their words? Early case said, no, that's not a search or seizure. There's no constitutional right to be free from government wiretaps. But then later it changed its mind and said, no, when we think about what the Fourth Amendment was designed to protect, which is, among other things, privacy, people's right to privacy, then it changed its mind and said, yes, in fact, when the government wants to wiretap someone's phone, generally it has to get a search warrant from a judge. It is essentially a search. Now, the way the court came to that conclusion is by analogy, which is often how these technological developments are addressed, because the court analogized wiretapping to old-fashioned eavesdropping, right? So, because people have been snoopy for a long time, right? Including the government, maybe especially the government. So, eavesdropping is when someone literally crept up to somebody's house, hung out under the eaves of the house, and listened on to the conversations going on inside. And essentially what the U.S. Supreme Court said is this is not unlike eavesdropping, and the law has long recognized that people have a right to be protected against that, whether it's your neighbor or the government. And so that's how they came to the conclusion that wiretapping is something that people have a right to be protected by through having a judge decide whether the government has some kind of good reason to listen in.
I'd like to talk about the amendment process. It's notoriously hard.
Yes.
So, can you just explain what it is? How is it possible to amend the Constitution? Is it a good thing that it's hard to do? Or, yeah, just let me know your thoughts on that.
The U.S. Constitution is notoriously difficult to amend compared to most other countries' constitutions. What it takes is it can be done in one of two ways. It takes two-thirds of each House of Congress, the House of Representatives and the Senate, to agree to propose a constitutional amendment. So there's that supermajority requirement in both houses. And then once a constitutional amendment is proposed, it has to be ratified by at least three-quarters of the states, which today would be 38. Which, and we can't agree on anything, and it's always been difficult to get that degree of support for things. The other way is that on the application of the states, two-thirds of the both chambers of Congress can call a convention for proposing amendments. So, but in either event, any kind of amendment, proposed amendment, has to have the agreement of three-quarters of the states to be effective. The folks who wrote the Constitution deliberately intended to make it hard to amend the Constitution. They were worried about, fads and people being sort of caught up in some sort of hysteria and amending the Constitution in ways that were imprudent and that had to be undone. And of course, famous example of that is prohibition, right? Even with those daunting requirements, the experiment of prohibition failed and had to be undone in a constitutional amendment. I think that the argument in favor of making it easier is that, particularly as time goes on, change happens faster and faster. And to the extent that the Constitution doesn't kind of keep up with it, there's a threat it becomes an obsolete document that people start to ignore. The danger is the one that the framers of the Constitution worried about, is to make it too easy, suggest that people will be amending the Constitution in all kinds of imprudent ways that only later have to be undone. So there's a trade-off there. I think most people would say it probably is harder than it should be to amend the Constitution, because there does seem like over the years there have been some proposals that seem to have very broad-based support that don't quite make it. Maybe the most famous example of that is the Equal Rights Amendment, designed to expressly protect the rights of women in the Constitution, that fell short just by a whisker.
And why is it important for people to trust the system? Like, even if they don't necessarily agree with a ruling from a judge or something, why is it important that they trust that the system is doing what it's supposed to be doing?
Ultimately, our safety and security and our rights when it comes to protection against the government depend on everybody following the law, including the government itself. And to the extent that people don't respect the law, they will feel more free to break it than to ignore it. And so we really need sort of mutual trust that everybody, generally speaking, for the most part, will obey the law, and that when judges interpret the law, they'll do so in a way that's really faithful and consistent and doesn't show favoritism. I think that's particularly a very big concern. People are very worried about there being different standards, for different groups, depending on things like political party or wealth or class in society. So, this concept of equality under the law, equal justice under the law, which is on the Supreme Court building itself, I think is really critical to the stability of the system.
How should they approach their jobs in a way that makes everyone know that they're coming at it from a place of sincerity?
Yes.
Um, eh, yeah.
Yes, it's a wonderful question, and so one of the things, it goes back to um, faithfully and in good faith applying the kind of interpretive methods we've been talking about and showing their work, right, and explaining themselves. One thing I didn't mention, but this gives me a chance to mention, is in addition to sort of the approved ways of interpreting the Constitution, there's also a one way not to do it, which is for judges to try to be result oriented and reach the result that they think is right in their gut in the particular case. And that's where the role of precedent comes in very, very importantly. We expect judges to decide similar cases consistently with the way these cases have been decided in the past. And that's really the role of precedent, right? That if the Supreme Court renders a decision, in the year 2000, it should follow that decision when a similar one comes along, a similar case comes along 20, 50, 100 years later, unless there are very good reasons for not doing it. That tends to restrain judges from doing just what they think is right in the individual cases. That's one of the reasons that we train law students who are often future judges. about what are the proper ways to go about and the traditional ways of interpreting the Constitution in a way that is accepted and that gets buy-in from people when these decisions are made.
Okay, now I'm just very curious. What is your number one thing that you hear people say something about the Constitution and you're like, "Listen, that's not correct."
Yes, my number one is definitely misunderstanding that the various rights that people enjoy under the Constitution are really only rights that are protected against government interference, not other kinds. So, for example, when someone is fired from their job because they say something that the boss doesn't like, maybe they're a supporter or a critic of President Trump, and they get fired for that because their boss is of a different view about the president. They'll often say, "Well, that violates my free speech rights." And the answer is no, it does not, because you have free speech rights that are protected against the government, but not against your boss, not against your neighbor, not against your friend. People misunderstand it sometimes and think that they're right. They have a free speech right will protect them from getting fired or getting blowback from other folks around them who aren't governmental actors.
Yeah, I could see that being frustrating. We're almost done here. I just wanted to open the floor to you. What's the big takeaway you want people to come away from this conversation with?
We live in a very divided country right now in terms of people who take extreme views, take up the majority of the airspace, you might say. And so I think it's important to know that there have always been very, very strong arguments and feelings about, for example, the Constitution and what rights it should protect and what rights it shouldn't, what limits it should put on government, what limits don't exist. And this comes up, for example, in terms of the president's power to deploy the military. I'm reassured, and I try to reassure people that these arguments have been going on a long time, and they're not necessarily unhealthy. There's certainly been some times when there's been virulent disagreement among people, and if you actually go back to the early 1800s and read some of the things that famous people like, James Madison and Thomas Jefferson were saying about each other, I mean, they were really quite nasty, and it got personal. So we sometimes hear the tenor of debate and then worry, are we unraveling? And I'd say, well, no, I don't think so. I think with the benefit of history, you realize we've gone through turbulent times and survived them. And so I think that should give reason for optimism.
Thank you so much for being on. This was a lot of fun.
Likewise, thank you for having me.
Okay, what did you think about that interview?
That was fascinating. As much as I loved what he was talking about at the beginning, breaking down the different points of view of how you look at the Constitution, what I loved was the fact that you asked the question about cruel and unusual punishment, and then he walked us through how the lens shifts on that topic. I found that fascinating, being able to break those down, kind of looking at how a judge would piece together their argument from these different points of view. It was just really helpful to see that happen.
Genuinely, I was so excited because I'm like, I understand this now. Because every time the Supreme Court is in the news, it's like, you've got this school of thought and this school of thought, but like, how do they really compare? It was really good to now have that information in my head.
I also loved the fact that you got to discuss how judges would bring new ideas that were just not even on the table when they wrote the Constitution. How they would start to break that down, and the fact that you do have to start in the past and work your way forward. I found that a really interesting part of the conversation.
The extrapolation that these judges have to do is quite impressive, actually. Thank you for listening to the Vandal Theory. You can visit our website at uidaho.edu/Vandal Theory to learn more about the work that we do. Email us at vandaltheory@uidaho.edu. We're on all the podcast platforms, so please rate and review and subscribe. I'm Danae Lenz.
And I'm Lee Cooper.
Thanks for listening.